My name is Joanne Peters, and I'm a partner at the law firm Isaac Brandt Ledman and Teeter in Columbus, Ohio. My phone number is 614-221-2121. I'm here to talk to you today very briefly about the right of an employer to intercept or access employee email. There's a federal statute, a couple of federal statutes that govern this, that collectively known as the Electronic Communications Privacy Act. The first part of that statute I want to talk about is 18 United States Code Section 2511. And in short, that section of the Electronic Communications Privacy Act prohibits the intentional interception of any electronic communication. There is an exception, though, that employers can take advantage of, and that's known as the ordinary course of business exception. Under that exception, if advance notice is given to your employees that you may intercept electronic communications that are made using your computers, then the interception is legal. A case I wanted to just mention is a case known, the name of the case is Bohawk versus City of Reno. And it is a case from 1996. And in that, the court explained that all that is needed is advance notice to employees that you may intercept their communications. In that instance, were police officers that were suing and saying it was unlawful for their police department to have intercepted or accessed their emails. And the court in that case held that the officers had no reasonable expectation of privacy when the police department had already warned them beforehand that their messages would be logged on the network. The other part of the Electronic Communications and Privacy Act I mentioned is the part that says that no one is to access electronic communications stored on equipment. And that is, you can't access them unless you have authorization. There's also an exception to this that employers can take advantage of, and that is that you're allowed to access the electronic communications or the emails, which is in most instances what we're talking about, if the emails were received through equipment that you provided to the employee. In other words, the seizures, to quote the statute, are authorized by the person or entity that provided the wire or electronic communications service. In this instance, an example I can give you is a case called Frazier versus Nationwide, where a Nationwide employee complained about Nationwide accessing an email. And in that case, the court held that because Frazier's email was stored on Nationwide's system, its search of that email was wholly proper. So as an employer, what does this mean for you? And this is where Isaac Brandt can help you. We can help you write a policy to make it clear to all employees that computers and all data on them are the property of your company, that no employee should have an expectation of privacy as to the content on the work computers, and that the company reserves the right to access all computers and electronic equipment at any time. Be happy to help. Give me a call, 614-221-2121.